Welcome to today's Power Hour. This is the Leave Law Lab over ADA, FMLA, pregnancy, PPWFA, and overlaps. It is presented by Mitch Guymond and Kyle Heslin of Ironwood Business Consulting. My name is Michaela Lavelle, and I am the Director of Events here at the Blue Springs Chamber of Commerce. We are so happy to have you here with us today. A couple quick reminders. We have a Power Hour session scheduled every month for 2026. They are on the first Tuesdays of the month, and they are always at noon. We are also recording each session and adding them to our resource center. So if you miss one, you can go back and watch it later by logging into your member information center. Before we get started, put your name and business or organization in the chat so that we know who's here with us today. We will be monitoring the chat for requests, and we will hold a Q&A session at the end. Today we have two presenters. Our first presenter is Mitch Guymond. He is a human resources coordinator at Ironwood and brings over 8 years of HR experience in the private sector. Prior to joining the Ironwood team, Mitch worked for two large international corporations within the security and tech industries. Mitch has experience within multiple facets of human resources, specializing in employee relations, investigations, compliance, ADA, FMLA, and training and development. Mitch has over 3 years of direct employee relations and investigative experience within both union and non-union environments. Mitch obtained a Bachelor of Science in Psychology from Washington State University in Pullman, Washington, is SHRM CP certified, and is a licensed private investigator in the state of Texas. Our second presenter is Kyle Heslin, SHRM CP. She is an experienced human resources consultant with a passion for helping organizations build strong and effective teams. Kyle specializes in providing expert advice and guidance on all aspects of human resources, including recruitment, talent management, employee engagement, employee relations, workplace investigations, employer branding, and compliance. Kyle is known for her strong communication and interpersonal skills and is skilled at building trust and rapport with clients and colleagues alike. Kyle holds a SHRM CP certification, SHRM's Workplace Investigation Specialty Credential, a private investigator license, and was elected to the Lewis and Clark SHRM Board of Directors as the 2024 and 2025 Communications Chair. She also received a Mental Health Ally certification from Psych Hub and a Diversity, Equity, and Inclusion in the Workplace certification from the University of South Florida Muma College of Business. Kyle graduated summa cum laude with a Bachelor in Science in Public and International Affairs from the University of North Carolina, Wilmington. Kyle lives in St. Louis, Missouri. Mitch and Kyle, we are so excited to have you here with us today. Thank you again for presenting. Are you two ready to take it away?
Yeah, I'm happy to dive right in, then I'll pass it over to Kyle here in a little bit. Well, thank you again for bringing us in. It's always fun to get to present to you guys. So today we're going to be covering a couple different leave laws and how they impact the workplace. Really, our goal today is to give everyone the knowledge they need to make sure that they're navigating through these different laws and their overlaps in a compliant manner, make sure that they're navigating through that accommodation process, and really try to foster an inclusive environment for individuals that may have disabilities or other conditions. So before we get started, just a quick reminder. So this is being recorded. If you have any concerns with being part of a recorded presentation, please reach out to the Blue Springs team. And then another disclaimer. So the content that we're covering today is really intended to be general guidance, and it's based on current laws and best practices. As we've seen over the last couple of years, laws can change. So it's always a good practice that if you are navigating through a tricky situation, take that extra minute or two to just double check current regulations. And if it's a particularly sticky situation, it's always a good idea to reach out and consult with legal counsel if there are potential litigation risks. So before we dive into kind of the overlap between things, we're going to be using a lot of acronyms today. So I wanted to take the time to define a few of them. So you're going to hear the term ADA, which refers to the Americans with Disabilities Act. So what the Americans with Disabilities Act does is it requires employers to provide reasonable accommodation for qualified employees with particular disabilities. You're also going to hear the term FMLA, which refers to the Family Medical Leave Act. So what FMLA does is it provides up to 12 weeks of job protected leave for eligible employees that are dealing with either their own injury or illness to a family member, or to care for a child post-birth or the placement of a child. We're going to be focusing more on the injury or illness to themselves today, though. There's also the Pregnant Workers Fairness Act, or PWFA. What that did, and it was kind of interesting when it was passed, but essentially provides the same sort of accommodation requirements as the Americans with Disabilities Act, but it expanded that to cover pregnancy and related conditions. Prior to the PWFA, there was kind of a loophole in the ADA where pregnancy itself wasn't covered, but any medical conditions that arose from the pregnancy would be covered. So this just kind of closed that gap. And then finally, we're going to be touching on the Pump Act, which specifically provides for break time and private space for nursing employees when they're in the workplace. So why does today's presentation matter? Well, a lot of leave situations, they're very rarely clearly defined at the start. You'll hear employees say things like, I need time off, or my doctor gave me a set of restrictions, or I can't do that part of my job right now due to some sort of condition, or I'm pregnant and I'm struggling. All these different situations can potentially spiral out and have different coverage under potentially one or more different laws. They're usually not coming out and saying, hey, I have an ADA or I need an ADA accommodation, or I'd like to take FMLA. A lot of the times it's usually more vague comments like, hey, I need some time off for medical treatment. And a lot of employees aren't aware of their rights under these different laws. So it really falls back on the employer to make sure that they're recognizing these signs and triggers so that they can then make sure that they're navigating through these different regulations appropriately. So what's today's goal? Well, ultimately, we want you to be able to recognize the triggers. So being able to identify when these different laws may apply based on the statements that an employee is making or the situations that they're bringing forward. We also want to give you some information on what the interactive process is and how to engage in it properly. There's a lot of phone calls that we get as part of our phone support where maybe they're navigating through part of the ADA process and then they hit a roadblock where they're not willing to consider something that maybe they should be. So we want to make sure that everybody has that clear understanding of what their obligations are. We also want to distinguish between those obligations between the ADA, FMLA, PWFA, and the Pump Act, because they do, even though there are some similarities in there, they do have different obligations and requirements. We're going to cover how to handle the documentation. A lot of the information you're going to be gathering is kind of skirting along that line of protected medical information. So we want to make sure that we're covering how to navigate through that. We're also going to touch on some of the common mistakes that we see that can open up the door to potential legal or operational risk. And ultimately, we want to equip you with the tools so that you can build your own process to make sure that you're navigating through it effectively. And ultimately, that'll be able to trickle down to your managers to make sure that everyone can follow it consistently. So the big picture, ultimately, each law is going to have its own obligations, and they could potentially apply simultaneously to a single employee situation. I had a phone call last week where an employee had a medical condition that started out as an ADA accommodation. In this case, they were struggling with work due to a specific condition, and then the condition escalated and turned into a situation where now they needed some time off, which was then falling under the FMLA side. If there's a pregnancy involved, that can potentially involve any of these, not just accommodations under the PWFA, but if they develop a complication like diabetes or postpartum depression, that could fall under the ADA. If they need time off related to the birth itself or an injury or illness, that could fall under FMLA. And then once they actually have the child, that's where the Pump Act would come in. So there's a lot of overlap in there. Additionally, a lot of states do have additional protections beyond those federal minimums. So it's always a good idea to look at, okay, what obligations might be triggered by this? What's going on in the situation? And then start digging into, okay, what do we need to do to navigate through this appropriately? So for the ADA, or the Americans with Disability Act, what do employers need to know? Well, the ADA ultimately prohibits disability discrimination and it requires reasonable accommodation for employees with known limitations. What that refers to are essentially a disability that impacts one or more of their life conditions or an essential function of the role. As employers, our job is to be able to recognize when an accommodation request might be triggered. An employee likely isn't going to be coming out and saying, "Hey, I need an accommodation." It's usually going to be something more like, "Hey, I've got this back condition and I'm struggling with lifting something." We're also going to be covering engaging in the interactive process, which is another key responsibility of employers. You need to engage in that process in good faith. Um, you need to consider effective accommodations. Even if an employee is coming out and requesting a specific accommodation, that doesn't necessarily mean that the employer needs to go with that accommodation. You do need to look at the whole picture. Maybe there's something that could be more effective, or maybe there's something that you can work out that will have less of an impact on the business itself while still accomplishing the same goals. You also need to protect the medical confidentiality and avoid retaliating against employees. And throughout this whole thing, the biggest thing is you want to document that process. If you're not documenting it, that's where a lot of companies get into trouble, where an employee can then come back and say, oh, the company didn't engage in the accommodation process in good faith, or they denied this unfairly. And if you don't document it, you have no way to defend those decisions. The other thing that's really important to note is the ADA is not just about permanent disabilities. It can be something like a broken leg or a broken arm potentially, as long as it involves medical limitations that are either impacting their ability to perform normal functions as part of life or an essential function of their role. That's when the ADA would come in. So it needs to either substantially limit one or more major life activities or an essential function. So what are some of the potential triggers for an ADA claim? Well, it's any statement that suggests a medical limitation connected to a job function. So it could be an employee saying, I can't work this schedule because of my medication, or my anxiety is getting worse, or my back injuries, meaning I can't lift that. Any of these could potentially be a trigger. It doesn't even need to be something that drastic. It could be the doctor says I need restrictions or I need some time off for treatment. One of the key things about the ADA process is each situation needs to be looked at on a case by case basis. So the accommodations themselves will look drastically different depending on the needs of the employee. But first, you need to be aware of those triggers and then scale that to HR so that the information can be protected. So the interactive process, easiest way I've found to understand it is it's not a way to lower the bar for the employee. It's not saying, hey, you have a disability, so we're not going to make you do your job. It's all about working with the employee and the employee's doctor to find a way to elevate that employee up so that they can perform at the same level as anyone else. They just need a little bit more help to do that. So broadly speaking, for the interactive process, it's going to start with identifying what are the essential functions of their role. For an employee who their role is largely computer-based, if they have a disability that requires a medical condition that could be accommodated by remote work, that might be possible because the essential functions wouldn't be impacted. But if, let's say, they occasionally need to drive as part of kind of a marginal function, then that wouldn't really be impacted by that accommodation. So the remote work would make sense. But for somebody who's in a driving role, driving would be an essential function. So you can't really remotely drive a car, or at least the technology is not there. So that's really where those essential functions and being able to identify them are key. From there, you need to understand what the limitation is. Depending on the specific condition and the restrictions, it can look a lot different, even if they do have the same condition. And that's where you really need to focus on what the employee cannot do, not necessarily what that diagnosis or the condition is. From there, you'll want to request documentation. Essentially, that's having the employee go to their doctor and provide information to outline what those restrictions would be. As a best practice, I recommend sending the employee with a copy of their job description so that the doctor can look at it directly. Back when I worked in security, I'd get a lot of doctor's notes initially where, we've got an employee who they can perform the majority of the functions, but we've got couple minor limitations, but these were for employees who, in their role, they were more likely to get into a use of force and needed to be able to defend themselves. So when I would send them with the full defensive tactics handbook, then we'd get those updated restrictions that were more accurate of their limitations. From there, you want to explore your options. Depending on the specific restrictions, there may be different ways you can accommodate. Some may be a little more advanced or necessitate a little bit more investment than others. But really, you need to look at that collaboratively and find something that works for both the company and the employee. But once you've got an accommodation in place, the process doesn't stop. Over time, the need for an accommodation may change, the effectiveness of the accommodation may change. And that's where you always want to look at it and assess and say, hey, is this working? Do we need to consider an alternative? Is this just becoming so burdensome that we need to look at an undue hardship, which we'll be covering a little bit later on? But really, you need to be looking at that throughout the process. And then any sort of decision making needs to be communicated, ideally documented in writing. And then just continue to follow up throughout that process to make sure that their needs are still being met and that the accommodation is still effective. So, essential functions. These are what the job actually requires. Not every duty in a job description is truly an essential function. So you want to look at the actual work being performed. For a delivery driver, being able to operate a motor vehicle would be essential, but for somebody who works as a remote IT professional, that may not be. For somebody who works in, let's say, banking, um, potentially there might be some roles that could be performed remotely, but there may be roles that require that face-to-face interaction. So being able to be present at work would be considered an essential function in those cases. So you want to look at things like, are the tasks truly essential for their role? When you look at what that role is it a core element? How often is that task performed? If it's something where maybe once a year they're touching something minor, it's probably more of a marginal task versus something they're doing every day. Additionally, you want to look at what happens if that task isn't performed. If it's something that, if it's not done, it's going to have a drastic impact, that might be essential. Can the task be reassigned temporarily? Is the function defined in the job description itself? We see this a lot as well, where a company maybe hasn't updated their job descriptions in a while, so it's not actually defined in there. And then, is this a preference, a tradition, or an actual business necessity? So you want to make sure that you're looking at what those core responsibilities are and making sure they're defined accordingly on the job descriptions. It's always a good idea to go through and review them periodically and make sure that they're up to date before relying on them when you're looking at navigating through an accommodations situation. So some examples of reasonable accommodation could be something like an employee needs a modified schedule. If you've got an employee who's got ongoing treatment needs that would be covered under the ADA, potentially allowing them to work half days on those days, make it up, or shifting their schedule around might be an easy way to accommodate that. Depending on their specific role, it could be remote or hybrid work. Post-COVID, we've been seeing a lot more requests for remote or hybrid accommodations because COVID showed that a lot of roles can be performed remotely. Things like temporary light duty, additional breaks depending on their needs, assistive equipment could be something like a screen reader or text-to-speech programs that would allow them to perform computer functions. Could be modified duties. In some cases, it may mean a leave of absence, which we'll be touching on a little bit more in depth, but if an employee needs time off to recover, even if FMLA doesn't apply, potentially they could still need a leave of absence, which would be covered under the ADA. Reassignment to a vacant position is kind of more of an accommodation of last resort, where if there's an open position and the employee's qualified for it, you should consider moving them into it as opposed to strictly terminating. And then it could be adjustments in training or communication. If somebody has a certain condition, they may need instructions to be provided in writing. Things like that are also considered accommodations. One key thing is when a lot of companies think about accommodations, they think about, oh, these are going to be super expensive. But a lot of accommodations can be fairly cheap, with the vast majority of them coming in at under $500. So let's say you need to deny an accommodation. Typically, you're going to want to be able to show undue hardship. So it's not just, oh, this accommodation is going to be inconvenient. It does require a genuine documented assessment of business impact. And when they're looking at that, if it does end up being pursued as a claim, then you want to look at the actual cost of the accommodation itself and the operational impact. Is there a safety impact? Are there staffing limitations? They look at the business size and resources. A small company is going to be looked at differently than a huge company. The duration of the accommodation and the impact on the essential functions. So there was a pretty big case back in 2017. It was Searles versus Johns Hopkins Hospital, where a company denied an employee an accommodation. So this employee was hearing impaired, and they requested a ASL interpreter, and the company denied it based solely on the cost. So when the courts were actually looking at this, the cost to hire an interpreter was going to be about $120,000. So the company said, hey, this is going to be an undue hardship. We can't afford to hire an interpreter for this employee. And the courts actually determined that there was no undue hardship in that situation because that 120,000 would have been less than 0.07% of the actual or the hospital's annual budget. So I've also seen situations where an accommodation that was $100 is considered an undue hardship because the company was tiny, they didn't have a lot of resources, and they were already operating in the red. So it really does mean taking that holistic look at the situation to say, hey, if it's an undue hardship, it's going to have a drastic impact. So kind of an example of that is just if you're going to outright deny it and say, we don't do that here, that's a terrible way to respond to an accommodation request. But if you're in that situation, it's always a good idea to look at it and go, hey, let's evaluate it. Let's see what kind of solution we can find. Again, that interactive process is interactive, means it's collaborative. So work with the employee to see if there's a solution there. And even if you do end up pursuing an undue hardship and saying, hey, there's just no way we can do this accommodation, you still want to look at alternatives as well. So when you're documenting it, you should be focused on what's job related and necessary. So the documentation should be to support the need for the accommodation or to support the decision. So it could be getting an understanding of their restrictions and the limitations they're experiencing. You'll want to find out the expected duration of those accommodations. Is it something that's going to be more long-term or is it temporary? You want to look at the job relatedness of those restrictions and the accommodation need, and then whether the employee can perform those essential functions. What you don't need is the employee's full medical history. You don't need to know about unrelated conditions that aren't being accommodated. You don't need treatment details necessarily, or private medical facts that don't affect the workplace issue. There's also some crossover with now I always forget the full acronym for it, but GINA, which essentially covers genetic information discrimination. A lot of the times when you're filling out those ADA requests and getting the medical authorization, there should be verbiage in there where you're not requesting genetic information so you can protect the company in those situations. So, I mean, I had one where an employee had a back issue that limited the employee's ability to tie their own shoes. The exact condition really didn't matter in that case. What did matter was, okay, this is the limitation. And then from our end, we needed to work with the employee and the doctor as well as our clients to make sure that we were able to satisfy the specific safety requirements of the footwear while still meeting those accommodations. It did take a while, but eventually we were able to find a slip-on shoe that satisfied all the necessary safety requirements and allowed the employee to return to work. So again, you want to make sure that when you're getting that information, you're focusing solely on the job-related elements and not, okay, we're going to go fishing for medical information. So while the ADA does have a leave provision, the interactive process is really more focused on trying to get the employee back to work and performing effective work. FMLA, on the other hand, is focused on providing protections in situations where the employee cannot come into work for a variety of reasons. These could be the employee's own health condition or family members. It could be birth, adoption, or foster placement. And then there's some additional components that cover military family needs. But again, FMLA is really focused on kind of the eligibility elements, the job protected elements, health benefit continuation, and then reinstatement rights. So after FMLA is exhausted, the employee does need to go back into their original role, or as close as possible if that role no longer exists. So with FMLA, it does require a 12-week leave period. The ADA, while it does provide leave, it's undefined. So there's no bright line, hey, this is the perfect amount that you need to require for ADA leave, and then you can end it. You do really need to look at it on a case by case basis. And even if FMLA is exhausted, the employee may still qualify for additional leave under the ADA. So, for example, let's say you've got an employee, they go out for surgery and they take the full 12 weeks. And then at the end of it, the doctor comes back with a note that says, hey, this employee needs 2 additional weeks. That's where you'll want to take a close look and say, hey, is it reasonable to grant the additional 2 weeks or determine if it's an undue hardship? Typically, those shorter leaves are easier to accommodate, whereas if at the end of FMLA, the employee's coming back and saying, or the doctor's coming back and saying, hey, this employee can't come back for another 6 months, 8 months, a year. In those situations, it's a lot easier to claim an undue hardship because then you're potentially looking at holding that position for 6 months, 8 months to a year. Um, the other key element is FMLA doesn't matter or doesn't really concern itself with the anticipated duration of the employee being out. You get 12 weeks. With ADA, if an employee is going to be out indefinitely, so you have no idea when they're coming back, that likely would not be covered under the ADA. However, that would still give rise to FMLA coverage. So again, when you're looking at leave as an accommodation, you want to look at the facts. So is the leave related to a disability related reason? And it does need to be related to the employee's own disability. So it does not provide coverage for family members who have a disability or things like that. And then is there an estimated return date? Like I just mentioned, if there's no estimated return date and it's truly being seen as indefinite, that would not be covered under the ADA. However, if they're saying, hey, this employee is going to be out for, we think, 6 months, then you at least have an estimated return date and it would fall under the ADA. And then would the leave help the employee return to work? Is it a situation where the employee can potentially recover? What's the operational impact on granting this leave? And then has the employer documented the analysis when looking at that leave as an accommodation? Particularly if you're looking at denying an accommodation, you want to be able to show that full analysis of this is why we can't accommodate that. And again, leave's not automatically required. So with the ADA, the core intention is to try and get those employees at work and performing. But there are situations where leave might be needed. So it's a good idea where if you can't find an accommodation, was leave considered before you're looking at something more serious? And then the final one that I kind of touched on before was transfer to an open position. That's really seen as a last resort that you should also be considering before you're looking at terminating as well. So similar to the ADA, pregnancy under the Pregnant Workers Fairness Act also requires accommodation. Like I mentioned, it kind of closed that loophole where sometimes the ADA would apply, sometimes it wouldn't, depending on if there were medical conditions involved. Well, the Pregnant Workers Fairness Act expanded that out to cover all elements of the pregnancy. So that could be things like more frequent breaks or allowing an employee to sit while they're working. It could be giving them access to water, temporary lifting limits, limiting exposure to hazardous chemicals that could interfere with the pregnancy, schedule changes, time off for appointments, potentially uniform modifications if their existing uniform no longer fits due to the pregnancy. These are all potential accommodations, and they don't necessarily require the employee to provide a doctor's note. However, you shouldn't treat a pregnancy as a reason to say, hey, you need to go home, we're placing you on leave. You do want to engage in that accommodation process because ultimately the goal of the PWFA is to keep pregnant employees working with support, not push them out, have them hang out on paid leave or unpaid leave until the birth of the child. So again, pregnancy is one of those ones that has a lot of overlaps. Like I touched on before, I mean, things like gestational diabetes, yes, that's pregnancy related, so it fall under the PWFA, but that could also have ADA implications. The pregnancy itself would fall under FMLA and have some interactions there. There's also the Pregnancy Discrimination Act that grants protections against discrimination for pregnant workers. And then even after the birth of the child, you have the Pump Act, which covers lactation, break time, and space rights. So when you're looking at a pregnant worker, you want to make sure that you're considering all of these circumstances and monitoring the situation to see, okay, are things developing where, okay, this employee is only asking for initial accommodations under the PWFA, but now they've got a condition that could fall under the ADA. Are they being placed on bed rest by their doctor? So we need to trigger FMLA early. Make sure that you're looking at the situation holistically. And again, you want to make sure that you're double checking your state laws as more and more states are adding additional protections in place to cover these situations, whether that's paid sick and safe laws to grant paid time off, whether that's paid maternity leave. All these different state laws can potentially come into play, and it's important to make sure that you're staying current on them. So the Pump Act, while this doesn't necessarily cover leave, it does have some specific requirements that can have an impact in the workplace once the employee has returned to work. So key to that is they need to have reasonable break time and a private place to pump for up to 1 year after the child's birth. So that space does need to be functional. So typically that means a chair they can sit in, an outlet where they can plug in their pumping machine, and it needs to be shielded from view. So you can't just have them out in a glass cubicle out in the middle of the office. It does need to be private and free from intrusion. So ideally you want to have some way to either lock it or keep people from getting in there when it's in use. And it needs to be available when needed. So if you have multiple employees that are pumping at the same time, you may need to either look at establishing a schedule for people to pump or establishing multiple locations where they can do that. And probably the biggest question we get is whether or not it can be a bathroom, which it cannot. So if you're creating a pumping space, it does need to not be a bathroom. So I've seen companies take conference rooms, throw up some curtains, add a lock on the door, and convert that into a pumping room. I've seen them take unused offices or potentially a storage room, clear it out, clean it up, put a chair in there, make sure there's an outlet, and convert that into a pumping room. But again, it just cannot be a bathroom. So one of the biggest things you want to do though is when you become aware of the potential need for a pregnancy or pregnancy accommodations, that's also a good time to start taking a look at, okay, what are we going to do when this employee comes back? And then that'll give you the time to start looking at designating a space for pumping and making sure you can navigate that proactively as opposed to now the employee's back and you're not prepared for it. You don't have a space and you're scrambling. So take the time to be proactive. So with all these different laws, there's a lot of potential overlap. And if you're only looking at it based on a single law or a single criteria, you're likely to miss something. So if you've got an employee who's pregnant and they start developing complications, they need intermittent time off, later they need pumping breaks, and they have a postpartum condition, there's going to be a lot of crossover there. I mean, the complications could fall under the PWFA, the ADA. If they need time off for treatment, could be FMLA, either with intermittent leave or potentially continuous leave, depending on those complications. As far as the intermittent time off, that's FMLA and ADA, depending on the situation. And if they're still pregnant, the PWFA. For pumping breaks, that's the Pump Act. And then the postpartum conditions could fall under the ADA, potentially FMLA, and the PWFA as well. So there's a lot of overlap there. So your thinking shouldn't necessarily be, okay, what laws apply? It should be, okay, what's going on in the situation and what are our obligations to respond? So I've got a couple different scenarios here. The first one, the doctor says they can't lift more than 20 pounds for the next 2 months. So when you're looking at this situation, you want to think about what are the essential functions of the job? Does it require lifting or is lifting incidental? In my role, I don't necessarily need to lift things a whole lot. I sit here behind a desk most days. But if I was working in manufacturing or some sort of production role where I am needing to lift things, that would be different. What's the source of the restriction? So in this case, it's a little bit unclear, but could be pregnancy related, it could be injury related, or disability related. Do we need documentation? In this case, the doctor's saying they can't lift more than that, so you should probably reach out and get a copy of that doctor's note or something outlining those restrictions. Can the employee's duties be temporarily modified? So can we accommodate not lifting 20 pounds? And who needs to be notified? In this case, you'd probably want to route it to HR, at least for the initial process, so that HR can work with the employee to establish an accommodation plan. But you'll also want to make sure that the employee's direct supervisor is aware of what accommodations are being offered in this situation. So for scenario two, you've got an employee who's exhausted FMLA and they say they can't come back for 3 more weeks. So a terrible response would be just saying, hey, your FMLA is exhausted, your job's no longer protected. You do need to still engage in that ADA process. While it's the employee in this case saying they can't come back for 3 more weeks, you'll want to see if that's due to a disability or condition or if it's the employee's choice. If the employee is stating it's due to medical restriction and it's supported by documentation from their doctor, there are obligations under the ADA, so you'll want to make sure that you're doing that full analysis. In this third scenario, we've got a pregnant employee who says she cannot stand for long periods and needs to sit during part of her shift. In this case, it would fall under the PWFA. So then you'll need to look at, okay, can she sit? Is seating available? Would the seat being seated prevent the employee from performing essential functions? If it's something where they need to be constantly moving around, maybe not. But for a lot of roles, yeah, having a chair available is a lot easier than dealing with a potential lawsuit. And then you can also look at would another accommodation work? In this case, with it being a simple request like that, you don't necessarily need medical documentation since it's under the PWFA. But if the employee came in and said, hey, it's due to a back injury or things like that, then you could push for that medical documentation to support the accommodation. And then you always want to look at, okay, is there a low cost fix that eliminates legal risk? You know, like I mentioned, a chair is a lot cheaper than a lawsuit. Allowing somebody to drink water at their desk, potentially a lot cheaper than a lawsuit if they're not working in an area with a lot of contaminants. So you really want to look at kind of the totality of the situation when making these decisions. But that's all the information I've got from my end. I'm going to pass it over to Kyle, and she's going to take it forward because the ADA does go beyond just dealing with employers or employees. There's also a lot of implication from the customer facing side. So take it away, Kyle.
Mitch. I do want to start this section with a small caveat that this area of ADA is not necessarily our expertise at Ironwood, but because I do work on the corporate side / the marketing side of operations, I do have some experience with it. And we know it's particularly relevant right now for you all, especially, so we did want to touch on it. So ADA compliance is not only an HR file or an employee accommodation issue. So for public-facing businesses, ADA risk can show up in how customers enter the building, use the website, register for events, communicate with staff, and even bringing service animals in or any accessing any of the services that you provide. So a lot of the problems that companies might run into, they don't start in actually the HR department. It starts at the front desk. It can start on the website or in an event registration form, or even with a well-meaning staff member trying to enforce a policy that they weren't necessarily trained appropriately on how to apply, or maybe they think they are applying it and they maybe go too far over the goal of that policy. So this can happen in your customer access and your physical spaces, on your websites or your online registration forms, in event accessibility or policies that accidentally exclude people with disabilities or specific disabilities. So even though HR might not own the actual physical brick and mortar facility, or they might not have a lot of say over the websites or the customer service, HR will often get pulled in to these kind of complaints when they happen. And that's why cross-functional awareness is exceptionally important and a big reason why we have included it within this Leave Law Lab. We just wanted to make sure that functional awareness is there and that we know that it matters, so we wanted to speak to it. So first we can start with Title III, which applies to many businesses open to the public. Thank you, Mitch. So the Title III covers many private businesses that are open to the public. They're often called public accommodations. And the point is equal access to goods, services, facilities, privileges, advantages, and accommodations. So this can be restaurants, it can be retail, hotels, medical offices, professional service providers, training facilities, private schools, gyms, theaters, and event spaces. Small businesses are not automatically exempt simply because they are small. Because some employment laws matter on the amount of employees that you have, but it does not necessarily matter for this. The obligations can vary by context as well. So a one-room professional office, a hotel, a restaurant, and a training facility, you might have different access issues, but you all should think about the barriers and the customer-facing procedures. The question's not really, are we too small for this to apply? The better question is, do we serve the public, and what barriers could prevent equal access? While physical access is the most visible piece, it is a lot broader than just, say, having a ramp, if you will. Thanks, Mitch. A ramp is only one access point. So a customer may be able to enter the building, but still be blocked by parking, the door hardware, a narrow interior path, inaccessible restrooms, too high of counters or signage, or even an event's layout, even if it's a one-time event and the layout is really constrictive. And even if it's just an older building, those buildings do not get a pass. For existing facilities, the practical concept is often removing barriers where readily achievable, meaning easily to accomplish without much difficulty or expense. So if it's an easy change to make, the goal is most likely to make that change. Just having a clear idea of how you want to go about making that change, and if it's a reasonable accommodation, that's where that will apply. A temporary event setup can create an access barrier, even if the building itself is accessible. A box in a hallway can block a wheelchair path. A high counter with no alternative service method can create a service barrier. Emergency exits and evacuation planning, of course, always going to matter too. The standard is not perfection by tomorrow morning. That is something we really want to make clear. The standard is good faith, documented attention to barriers, and reasonable steps to address them. Many issues start even more casually, just in the customer service interactions themselves. So an example of a customer-facing ADA issue may look like a normal customer service request. It could be a help with a form, a service animal on the property, a communication need, difficulty accessing a counter, or inability to use online scheduling. The biggest risk here is improvisation. So, and that's not necessarily going to be by the managers. It could be by front level customer facing staff, in case they just try to do a remix or do an improvisation, if you will. They may think they're following the policy and say, we can't help with forms, or there's no animals allowed, or you have to use the website, or that seating is reserved. And those responses could potentially contradict ADA obligations of no accommodations or alternative access paths if that's evaluated. So the goal is really to train the staff to pause and potentially reroute. A frontline employee does not need to solve every issue, but they do need to avoid making a rigid denial or asking potentially inappropriate questions. The best response to this is typically, let me get the right person to help us review what options are available. That's going to be a great line to really use. You can use it in pretty much any situation, and it's good customer service as well. I might not have the answer. Let me get with someone who I know does. And that gives you some time to breathe, make sure that no decisions were made that wouldn't fit a policy or would potentially violate ADA. And it's just the safest route possible. It keeps the interaction respectful and reduces the chances of escalation as well. ADA customer service training should be a part of onboarding for anyone who interacts with customers, visitors, registrants, patients, clients, or event attendees. So just putting it into any customer service training you have is also a big bonus. Service animal issues are one of the easiest areas for staff to mishandle because people have strong opinions and there is a lot of misinformation out there, a ton of it. When the need is not obvious, staff may ask only two questions. Is the animal required because of a disability? And what work or task has the animal been trained to perform? That's it. And even that might be too many. Staff should not ask for any medical documentation, certification, an ID card, a demonstration of the task, or details about the person's disability. They should also not debate whether the disability looks real because there are very much things called invisible disabilities, and we aren't expected to know all the ins and outs of that. Just following the procedure is the best case scenario. Your business can have rules of conduct, but it should not turn the situation into a confrontation. If there's a legitimate behavior issue, such as an animal being out of control and the handler not taking effective action, make sure they just route that to the manager and make sure the manager is equipped with the proper training. I like to say two questions and don't freelance, don't improvise. So those two questions is the animal required because of a disability, and what work or task has the animal been trained to perform? But service animals are only one form of access. Communication access is a completely different element. So effective communication means the person with a vision, hearing, or speech disability can receive information from, communicate with, and participate in the business's services just as effectively as anyone else. The right auxiliary aid or service depends on the context. A short, simple transaction may only require writing notes. A complex medical, legal, financial, HR, or training discussion may require a qualified interpreter, closed captioning, accessible documents, or another more robust support. So some examples are written notes, captions, large print materials, screen reader-friendly documents, qualified interpreters, assistive learning devices, accessible online forms, and alternative access methods. We only do it one way is a bit risky. It might require a couple more steps on the business's end, but at the end, it could save you a lot of frustration from both your end and the clients or the customers. If the only registration path for a website it's one that someone cannot use, a backup plan is always suggested. If the handout is only inaccessible, if the handout is an inaccessible PDF, there should be an accessible version as well. So the best way to kind of go about it when you're trying to maybe audit your different communication tools is, how would someone with a hearing, vision, or speech disability access this information or service? If no one can answer, that could potentially mean that there's a gap. This is the least fun, but the most interesting to me personally, because I do work on websites, but it's complicated. So don't think you're supposed to absolutely understand all of this. You're not, unless you are a website expert. But website and digital accessibility are now core business areas primed for risk. So customers, applicants, members, and employees often interact with businesses online before they ever even talk to them in person. Or maybe that's the only way they communicate. Some common gaps that might violate ADA accessibility: images without alternative text, videos without captions, poor color contrast, forms that do not work with keyboards or screen readers. So if it's just a mouse and you can't actually access each different blank, if you will, through the actual keyboard, that could qualify. PDFs that are just scanned images, inaccessible job applications, mobile issues. So if it's great on desktop but not on mobile, and third-party tools that could block access. One important nuance is that ADA.gov guidance explains that businesses open to the public have ADA obligations around web accessibility, even though the technical requirements and enforcement landscape can be complex. For state and local governments, updated Title II web rules use WCAG 2.1 level AA as the technical standard. I don't expect you to remember that, but we can send out this presentation as well, so you'll have that to go back to. That's kind of the practical benchmark when you are trying to make sure you are web accessible compliant. So it has a long list of all the different requirements that it has. So one practical test is, if a customer or applicant cannot use the online process, what is the backup plan? Phone, email, in-person help, or an accessible alternative form may reduce risk while the digital issue is fixed. So if you can't do something in the moment, if you don't have that web expert, technical expert, IT expert, right on staff with you that can make certain updates and audit the different pages on your website. Those are just some examples. This becomes especially visible when businesses host events or trainings. So that could be where a lot of the web access is coming from, and where issues might pop up that might not have popped up in the past. So anytime you're hosting an event is a good time to think about auditing your website if you haven't in a while. So yeah, as I said, events, trainings, and even meetings are also apply. So it's not just a physical building. It's not just a day-to-day thing. If you're hosting special events, trainings, and meetings at your organization or even online, that's where accessibility planning should happen before the event and not at the registration table or the registration link. You can walk through this checklist if it's in person, accessible entry, parking, restrooms, seatings, microphones, captions or interpreters if needed, and when needed, medical dietary needs if needed, readable slides, accessible handouts, registration forms that invite accommodation requests if needed, and a clear contact person. This gives attendees a path to ask, especially, and it gives the organizer time to evaluate options. It also shows good faith planning. So that's what having a contact person will always be helpful. If you need an accommodation, a good suggested language on the registration form, or however you are gaining those different who's going to attend. If you need an accommodation to participate, please contact us by X date so we can review available options. So that's just a little footer you can put on. Even event accessibility is not only about avoiding complaints, it affects attendance, reputation, professionalism, and whether people can fully participate. And a lot of the risk comes from the gap between what the policy says and what the employees actually do. So you can have it all in your policy, but sometimes that remix or that improvision is what can bring up some issues. Policies are not magic shields. If a written policy is compliant, but the frontline behavior is inconsistent, dismissive, or rigid, the business still has risks. I have a few more slides, so that's pretty much self-explanatory. So we can go on to the next slide, Mitch. This one's pretty valuable. You can do this as like a starter audit, but it's not like a full legal audit by any means. The goal is just to identify any obvious gaps and assign ownership. So in terms of physical access, can people park, enter, move through, use restrooms, or reach the service areas? And then service animals. Do staff know the 2 questions that they can ask, what not to ask? Digital access. Are websites, PDFs, forms, and videos usable or backed up by an alternative method? Manager routing. Do managers know where to send employees and customer ADA issues? And documentation is on the next slide, so I can go over that. But assign each category to an owner, set a 30-day review window, list any gaps, prioritize any high impact fixes that you might find, and then document the corrective action. It would be the best way to do a simple audit that you guys can do on your own. So we can apply that to the next business scenario. The situation is your business hosts a training event. A registrant says that they are deaf and asks whether captions will be available. Another attendee plans to bring a service animal, and the venue also has limited accessible parking. So you can walk through the questions. Who owns the response? What information is needed? What can we ask and what should we not ask? Does the venue meet these standards? Are handouts and slides easily accessible? What should front desk staff know before the event? And what should be documented? So some takeaways. Make access someone's responsibility before it becomes an emergency. Train frontline employees first. They're the ones most likely to encounter these different service animals or communication needs. Review physical access proactively. Make digital content usable and accessible to all. Add accommodation language to event registrations. And that's just a really good way to start forming policies and applying them universally across. ADA risk. Business risk is manageable when it is operationalized, so it becomes messy when everyone assumes someone else owns it. Some common mistakes that we might see are ignoring those informal requests, asking too much medical information, rigidly applying policies, pregnancy assumptions, confidentiality briefs, manager-only decisions, skipping the documentation, leave exhaustion and termination, not following up after the fact, and any forms of retaliation will always be a common mistake. We did a session on documentation, I believe not last month, month prior. And this is kind of just, it speaks to that again. So if you sat in that meeting, this will be some repetition, but documentation is always going to be paramount to protecting your business. The purpose is not to create a mountain of paperwork. It's to show that you have reasonable, good faith process in place and how you can adapt that in the future to make sure you're doing that good faith corrective action. So, and another thing is if it's not documented, it still might have happened, but it might be much harder to prove later. So having that bulletproof documentation is a very big asset to your company, and we can send that along too if anyone ever needs it. We have that presentation as well. A quick manager training checklist. Managers should know what phrases trigger HR involvement, not to ask for diagnosis details, not to promise approval or denial, not to retaliate or change treatment against different individuals, how to document the initial conversation, who to contact internally, and what to say in the moment. A script will go a long way, even if it's not word for word, just the overall script. To make this easier, you can use the pause method, and that's on the next slide. This is just a really good method to kind of train your employees on all across the board. And that's pause. It's pause before reacting, ask what the employee needs, understand which laws may apply, seek documentation when appropriate, and evaluate options and then document. Right to the line. So here's some takeaways that we hope you gain from this session, and that's to train managers on trigger language, centralize accommodation requests. So whether they're formal or informal, they should flow through a single consistent process. Update any leave and accommodation processes with any gaps you might have found. Create those documentation templates. Audit your pregnancy and lactation practices if needed. Review public-facing ADA risks, whether that's physical access, digital access, or event access. And then know when to call legal counsel or HR support, or even Ironwood. And just to close, leave law is not about memorizing every statute. It's about recognizing when a routine workplace issue may carry any legal obligations. So that's noticing a trigger, slowing down the process, and documenting the process. When in doubt, pause, reroute, document, evaluate. This is just a list of sources where we find our information. And so that's a lot of this comes from the government websites.